Hello everyone, welcome back to Madad IAS. We are going to complete page wise, chapter wise exact questions from M.Laxmikanth for the year 2018. So, this is part 14 of that video. If you are new here, please go back and look at the 2005 video. You'll understand what we're exactly doing here. We are mapping out the prelims questions for UPSC CSE in our book Lakshmikant. Without further ado, we are going to start with the first question of 2018. The topic is Government of India Act 1935. In the federation established by Government of India Act of 1935, residuary powers were given to them. The answer for this can be found in chapter 1, page number 8. Historical background under Government of India Act features. Point number 1. The features of this act were as follows. Very clearly it's written the residuary powers were given to the Viceroy, Governor General. So answer becomes B, Governor General. Coming to question number 2, the topic is Aadhaar. Consider the following statements. Aadhaar can be used as a proof of citizenship or domicile. Once issued, Aadhaar number cannot be deactivated or omitted by issuing authority. Both of these statements are incorrect statements. This particular question is a current affairs oriented question and is not given in Lakshmikant. Coming to question number 3, the topic is fundamental rights. Right to privacy is protected as an intrinsic part of right to life and personal liberty. Which of the following in the Constitution of India correctly and appropriately imply the above statement? We look at all the statements. We go to chapter number 8, fundamental rights, page number 90. Under Supreme Court has reaffirmed its judgment in the Menka Gandhi case. In the subsequent cases, in the Menka case and the subsequent cases, it has declared the following rights as a part of Article 21. Right to privacy is a part of right to life and personal liberty. Answer becomes C, Article 21, and the freedoms guaranteed in the Part 3. Coming to question number 4, the topic is precedents. Here we can go to very specifically go to chapter 18 of M.Laxmikanth, Precedent, page number 187. With reference to the election of President of India, consider the following statements. The value of vote of each MLA varies from state to state. Okay. The value of vote of MPs of Lok Sabha is more than the value of the vote of MPs of Rajya Sabha. Now here we go to page number 187. Parliament is entitled to cast that such elections shall be determined in the following manner. Point number 1. Every elected member of the Legislative Assembly of a state shall have as many votes as there are multiples of 1000 in the quotient obtained by dividing the population of the state by the total number of the elected members of the assembly. This can be expressed as value of vote of an MLA is equal to total population divided by total number of elected members in the Legislative Assembly into 1 by 1000. Now statement 1 is correct. The value of MLA's vote is not uniform across India. It is calculated based on state's population. Currently it's using 1971 census data divided by the total number of elected members of Legislative Assembly. Because population and the number of state assembly seats differ by state, the vote of value can be varied. For example, in 2022, MLA from Uttar Pradesh had a vote value of 208, while an MLA from Sikkim had a vote value of 7. Coming to statement 2, the statement 2 is incorrect. If we can very clearly see here, the formula for the vote of an MP is equal to total value of votes of all MLA of states, which is going to be a constant number, divided by total number of elected members of parliament. Again, this is going to be a constant number. From here we can see the MPs of parliaments, whether they belong to Lok Sabha or Rajya Sabha, will have the exact same vote value. And whereas for an MLA, it is going to change. For 2022 presidential election, this value was fixed at 700 for all MPs, for every MP. So answer becomes only 1 is correct, statement 2 is incorrect. Coming to next question, the topic is governor. We come to chapter 30, governor, page number 315. Consider the following statements. No criminal proceedings shall be instituted against the governor of state in any court during his term. The emoluments of the allowances of the governor of a state shall not be diminished during his term of office. We come to point number 6 here. His emoluments and allowances cannot be diminished. Correct point. Like the president, the governor is also entitled to a number of privileges and immunities. She enjoys personal immunity from legal liability for his/her official acts. During his or her term of office, she is immune from any criminal proceedings, even in respect of his or her personal acts. She cannot be arrested or imprisoned. However, after giving 2 months' notice, civil proceedings can be instituted against him in terms of personal acts. So here both our statements become correct. The answer becomes C, both 1 and 2. Coming to question number 6, the topic is parliamentary committees. With reference to Parliament of India, which of the following parliamentary committees scrutinizes and reports to the House whether the power to make regulations, rules, sub-rules, bylaws, etc. conferred by the Constitution or delegated by Parliament are being properly exercised by the executive within the scope of such a delegation. For this, we go to chapter 24, Parliamentary Committees, page number 278. Under committees to scrutinize and control, this statement is word by word given here. Committee on Subordinate Legislation. This committee examines the reports on the House whether the powers to make regulations, rules, sub-rules and bylaws delegated by the Parliament or conferred by the Constitution to the executive are being properly exercised by it. Answer becomes B, Committee on Subordinate Legislations. Coming to question number 7, the topic is Speaker. We go to chapter 33, State Legislature, page number 339. Under very specifically, so for these statements are about the Speaker of Legislative Assembly shall vacate his or her office if he ceases to be a member of the Assembly. Whenever the Legislative Assembly is dissolved, the Speaker shall immediately vacate his office. Okay. Coming to point number 1, of course, this is correct that a speaker ceases to be a member of the assembly, so he is going to not be the speaker anymore. But for point number 2, we have to, this is not necessarily directly given in Lakshmikant. If we read in the Constitution under Article 179, below point number C, provided further that whenever the assembly is dissolved, the speaker shall not vacate his office until immediately before the first meeting of the assembly after dissolution. So the speaker is going to hold office very specifically uh, till the newly constituted assembly is not formed. So he's going to, he continues to hold office until immediately before the first meeting. So he's not going to immediately vacate his seat, he's going to wait until the new constituted assembly is there. So answer becomes A, 1 only correct, second statement is incorrect. Coming to question number 8, the topic is emergency provisions. If the President of India exercises his power as provided under Article 356 of the Constitution in respect to the state, then okay, so here we are going to chapter number 17, emergency provisions, page number 179. We read all the points here. This particular point number B, the power of the legislature of the state shall be exercisable by or under the authority of the parliament. This answer is given here under the consequences of president rules. Point number 2, president can declare, she can declare the powers of the state legislature are to be exercised by the parliament. So this is a correct statement. The other statements are incorrect, as the suspension of fundamental rights. So Article 19 is suspended under national emergency, not under president's rule. And while the president can make laws. While the president directs the administration, legislative power is transferred to the parliament. They are not solely directed to the president, though the parliament can authorize the president to make laws. So this statement also becomes incorrect. The Assembly of India state is automatically dissolved. Nothing like that happens. Coming to question number 9, the topic is 9th schedule. We go to chapter 8, fundamental rights, page number 103. Now here if we read, the Parliament of India can place a particular law in the 9th schedule of the Constitution. Now this is a correct statement. Coming to point number 2, the validity of a law placed in the 9th schedule cannot be examined by any court and no judgment can be made on it. Here we can read from the third paragraph. Again, in the Iyer Kahlo case 2007, the Supreme Court reaffirmed that the above view. In this case, the court ruled that there could not be any blanket immunity on the judicial laws of the laws included in 9th schedule. It held that judicial review is a basic structure and it could not be taken away. So all the laws placed under the 9th schedule after 24th April 1973 are open to challenge in the court if they violate fundamental rights guaranteed under 14, 15, 19 and 21. So answer becomes 1 only, second statement is incorrect. Coming to question number 10, leader of opposition. Consider the following statement. In the first Lok Sabha, the single largest party in the opposition was Swatantra Party. This is incorrect. It was Communist Party. This particular line is not given in Lakshmikant. It might be given in NCRT, but I'm not sure. Coming to question point number 2, in the Lok Sabha, leader of opposition was recognized for the first time in 1969. Now, both these statements are given in chapter 23, which is the chapter of Parliament, page number 234 and 235. Under leader of opposition, very clearly it was in 1969 that the official leader of the opposition was recognized for the first time. In the Lok Sabha, the party does not have minimum of 75 members. We come here. The answer is not minimum of 75 numbers. The answer is uh, according to the directions issued by both chairman and the speaker, the minimum numerical strength required for recognition of a political party is 1/10 of the total membership of the house. So the answer is 1/10. So here, if we see, for a party's leader to be recognized as the leader of the opposition, the party must have a minimum of 10% of the total strength of the house. In the Lok Sabha, the total strength is 543. The requirement is 55 members, 10% of that, not 75. Statement 3 and statement 1 become incorrect. Only the statement 2 is correct. Coming to question number 11, this is not directly given in Lakshmikant, but I think this might be given in the NCERT. And it's also a fairly logical question. Which one of the following reflects the most appropriate relation between law and liberty? We can see here, if there are no laws, there is no liberty. This is technically a fundamental philosophy of John Locke, who wrote, where there is no law, there is no freedom. I'm pretty sure that it might be given in NCERT. Again, these are very vague statements. If there are more laws, there is less liberty. There is liberty, laws have to be made by the people. If laws are changed too often, liberty is in danger. Statement 2 is the one that fits the most. Coming to question number 12, the topic is fundamental rights. Which of the following are regarded as main features of the rule of law? Chapter 8, fundamental rights, page number 78. Under rule of law, the concept of equality between rule of law is an element, a concept of propounded by A.V. Dicey. Point number 1, absence of arbitrary power. That is, no man can be punished except for the breach of law. Limitation of powers. Equality before law. Equality before law. Liberty and civil rights. The primary rights in individual is a constitution is a result of rights of the individual as defined and enforced by the courts. So 1, 2 and 4 are the correct answer. Point number 3, people's responsibility of government is incorrect, as there is no feature like that. The government is responsible to the people, people are not responsible to the government. Answer becomes 1, 2, 3. Coming to question number 13, the topic is money bill. Regarding money bill, which of the following statements is not correct? We go to chapter 23, Parliament, page number 247. Under money bills, Article 110 of the Constitution deals with the definition of money bill. It states that the bill, so we are asking here not correct. So technically 3 statements would be correct. The imposition, abolition, remission, altercation or regulation of any tax. Point number A is directly written here. It's correct. The custody of consolidated fund of India, the contingency fund of India. Again, point number B is correct. The appropriation of money out of the consolidated fund of India. Okay, so C statement becomes incorrect because the appropriation of money out of the consolidated fund of India, not the contingency fund of India. A money bill deals with the regulation of borrowing of money or giving any guarantee by the government of India. Here, if we can see the regulation or the borrowing of money by the union government. So A, B, C are like correct statements. We are asked incorrect statement. Statement C is incorrect. Word by word, this was given in Lakshmikant. Coming to question number 14, this is not in Lakshmikant. As per the Right to Education Act, this is relatively a current affairs question. Right to Education RTE Act, to be eligible for appointment as a teacher in the state, a person would be required to possess the minimum qualification laid down by the concerned State Council of Teacher Education. No. The minimum qualifications are laid down by the Central Academic Authority, NCTE, not the State Council. Statement 2 is a correct statement, so answer is only 2. Statement C is again incorrect. Large majority or 60-90% of teachers institutions are private. Here they are saying more than 90% of teachers are directly in the state government, which is an incorrect statement. It is also a logical statement for it to be incorrect. Coming to question number 15, how is the National Green Tribunal different from Central Pollution Control Board? This is technical environment plus polity question, not directly given in Lakshmikant. The NGT has been established by an act, whereas the CPCB has been given an executive order of the government. Statement 1 is incorrect. Both of them have been established under an act. This has been established in NGT Act 2010. This has been established under the under the Water Act, Prevention and Control of Pollution, 1974. So statement 1 is incorrect. Statement 2, NGT focus on legal remedies, whereas CPCB focus on technical pollution control and standards. Statement 2 becomes correct. So we've completed 2080 polity questions. The entire purpose of this is for us to sit down and open Lakshmikant and revise from the book directly while doing the questions and not get too overwhelmed with the questions. If you have watched this video till the end, I have a small request. I know that there has been a certain delay between the videos. I don't want to go too deep into that. We're going to discuss that later on, but there were some really problematic personal issues at our end, which is why we couldn't post out videos so regularly. But what we're trying to do now is that before prelims, we're going to cover a lot more subjects and a lot more videos. It's a small request. If you like this video, any small comment is something that is very encouraging. So, would love to hear your reviews on that. Thank you so much.